In a dramatic turn that underscores rising tensions between the executive branch and the judiciary, President Donald J. Trump's legal team appeared to undercut its own position in front of the nation's highest court, raising serious questions about both the soundness of the administration's legal strategy and the broader implications for executive power. What began as an attempt to defend sweeping tariff authority quickly devolved into a cascade of contradictions and exposed vulnerabilities that may reshape how the Supreme Court of the United States, SCOTUS, views the limits of presidential emergency powers. Background and stakes. The case centers on the administration's invocation of the International Emergency Economic Powers Act, (IEEPA), to impose expansive tariffs on imports from nearly every trading partner of the United States. The White House argues that these tariffs serve national security and economic stability objectives, and that the president may rely on IEEPA's emergency powers to bypass the legislative process. Legal challenge after challenge, including suits by states, businesses and trade associations, have pressed that IEEPA was never designed to permit sweeping tariff imposition in lieu of congressional trade authority. On one side of the courtroom, advocates for the challengers emphasize that Congress retains sole authority under Article I of the Constitution to lay and collect duties and regulate foreign commerce. They contend that IEEPA does not explicitly mention tariffs or duties and has never been used previously for unilateral taxation-style import levies. On the other side, the administration asserts that IEEPA's language empowering the president to regulate importation provides a sufficiently broad granted power to support its tariff regime. The stakes could hardly be higher. If the court upholds the administration's reading, the president would gain enormous unilateral power to reshape trade policy via emergency declaration, sidestepping Congress entirely. If the court rejects that reading, the decision could narrow the scope of presidential emergency powers and reaffirm the legislature's primacy in trade regulation. What went wrong? The live moment unraveling. During a widely watched oral argument session before the Supreme Court, the government's own Solicitor General, appearing on behalf of the Trump administration, delivered a defense that startled observers, including some justices. At the heart of the trouble, a defense that the tariffs were not really for raising revenue, a cornerstone of the challenger's case, even though the president himself had repeatedly touted the revenue-raising benefits of the tariffs. The government argued they were regulatory tariffs whose revenue consequences were merely incidental. Justice Sonia Sotomayor posed a pointed rhetorical question during the argument. You want to say tariffs are not taxes. But that's exactly what they are. Other justices, including Chief Justice John Roberts, probed whether the vehicle the administration was using was simply a tax in disguise and whether Congress had constitutionally delegated that taxing authority to the executive. The court's skepticism was palpable. To compound matters, the president publicly boasted after the hearing that his tariffs were bringing in hundreds of billions of dollars. In the same breath, the administration's courtroom defense claims the revenue-raising element was only incidental. That gap between the public rhetoric and legal argument gave critics a potent narrative. The administration is relying on a legal theory that the president himself appears to contradict in words. In short, the government's argument appeared to undermine itself by simultaneously, A, claiming the tariffs are not a revenue tool, so as to comply with the challenger's framing, and, B, still celebrating the revenue raised, so as to appeal politically. That internal inconsistency created a moment of vulnerability in front of the court and in the public discourse. Broader implications for executive-legislative balance. Legal scholars say the outcome of this case may become a watershed moment for separation of powers. The administration's claim, if accepted, could enable presidents to impose broad economic measures, including tariffs, based solely on a national emergency declaration, without going through Congress. The effect: diminished legislative oversight of trade and potentially other policy areas. Conversely, a decision striking down the administration's reliance on IEEPA would reaffirm that major policy shifts of this magnitude must pass through Congress. It would check the tendency of executive power to expand via emergency law and preserve the constitutional role of elected legislators in trade and economic policy. The court's skepticism during the argument already signals it may be inclined to curb the administration's theory. Analysts argue that the word regulate in the IEEPA was never intended to include a sweeping tariff power or to substitute for congressional duties. Indeed, prior administrations had never used IEEPA to impose broad tariffs, which suggests the current usage is exceptional. Moreover, accepting the government's position could set a precedent for future presidents to declare emergencies and impose sweeping economic, regulatory, or even social policy changes, bypassing Congress under the guise of national security or economic threat. The potential for a slippery slope is clear. Political fallout and optics. Beyond the courtroom, the episode creates unwelcome optics for the administration. Critics will seize the moment as evidence of overreaching shaky legal grounding. The mismatch between rhetorical boasting, tariffs bringing in money, and legal defense, they are not revenue-raising, offers a narrative of inconsistency and potential confusion in the White House's messaging and legal approach. For Congress, especially members of the opposition and even some moderate members of the president's party, the spectacle may strengthen calls for increased oversight of executive emergency declarations. Some legislators may push back against future attempts to impose policy change without traditional legislative processes. The case could galvanize bipartisan interest in reforming or clarifying the scope of emergency powers and trade authority delegations. Business interests and trade-dependent industries are closely watching. Many companies already face increased costs from the tariffs and uncertainty about refunds or adjustments if the court rules the tariffs unlawful. The legal limbo itself is costly. The president's argument that a loss at the court would cause an economic disaster underscores how politically and economically entangled the matter is. Risks for the administration. From a legal risk standpoint, the administration's position is untested in precedent. The challengers argue that the administration is attempting to expand EPA beyond its intended boundaries. That argument is supported by the fact that EPA has historically been used to impose sanctions, export controls, or block access to foreign property, not to impose blanket tariffs on imports from friendly nations. If the court rules against the administration, the legal consequences could include not only a revocation of the current tariff regime, but also potential legal challenges seeking refunds or restitution for companies that paid the tariffs believing unlawful. The impact could ripple through global supply chains and result in political backlash. Another risk is reputational. The legal team defending the administration now appears to have less clarity or cohesion in the messaging, a dangerous position when arguing before the Supreme Court, where textual clarity, statutory history and precedent carry significant weight. The thinness of the government's argument may damage credibility. Finally, the broader political cost is not trivial. As the president often frames economic policy as a key part of his re-election argument, a major legal defeat in front of the court could undermine that narrative, embolden critics and narrow a margin for error politically. What to watch. Observers will be closely watching how the Supreme Court frames its decision, particularly how it addresses whether EPA grants tariff authority and how much deference the executive receives when claiming national emergency power. Will the court hold that the statute's plain meaning does not support tariffs? Will it emphasize constitutional separation of powers concerns? Will it set limits on how broadly a president can interpret emergency laws? Another key question, will the court require Congress to speak more clearly when delegating major policy powers to the executive? The major questions doctrine suggests that when a policy move has enormous economic and political significance, Congress must provide explicit authorization rather than leaving ambiguity. That doctrine looms large in this dispute. Businesses and international trade partners will watch for how refunds or adjustments are handled if the court strikes down the tariffs. Will there be retroactive consequences, or will future tariffs be restructured? Will the administration pivot to alternative statutory authorities, such as Section 301 or Section 232 of the Trade Act of 1974, which have slower but more traditional processes? Politically, the timing matters. The president's base will likely defend the use of tariffs and strong executive action, but the uncertain legal foundation may generate internal disagreement within his party. The opposition will likely use any legal setback as proof of overreach. Conclusion. In sum, what started as a marquee moment for the administration, a bold an attempt to reshape trade policy via emergency power, instead became a vulnerable moment. The president's own words about tariff revenue, combined with a courtroom defense that sought to deny revenue-raising intent, created an apparent disconnect. In the face of pointed questions from the justices, the administration's argument appeared to falter. The outcome of this case is poised to have long-term implications for how expansive presidents can interpret emergency powers, how much Congress must remain involved in major policy decisions, and how legal counsel navigates the fine line between political messaging and statutory argument. Regardless of which side the court ultimately lands on, this episode will be cited in future debates about the presidency, emergency powers and the constitutional balance between branches. For now, the administration is in a defensively awkward posture, its legal theory exposed, politics entangled, and institutional guardrails under strain. The Supreme Court's